first of all, they saw it as the breakdown of a marriage and divorce. Large sections of the women in this country see that divorcee is socially and economically not treated well. And they said that how can you introduce, further women's group specifically said, how can you introduce a ground of divorce which will allow men to have an unfair advantage over women, because if they want to get out of the marriage, they can do so in circumstances in which the woman's right to marital property is not recognized at all. The productive work that she does in the household is not recognized. The fact that she is an equal partner in the marriage is not recognized by our law. So when the marriage breaks down, it means that the man has gained from all the work of the woman. He has gained in stature. She has allowed him to work while she has either neglected her work or not worked and done the housework. She is the primary carer of the children. She is the person who maintains the household in almost all houses. So that is the norm. And if you pass the law, so they ask for equal rights to marital property. That is, rights to property that has been acquired during the marriage. And this law exists in several countries. In fact, it is mandatory to divide property which is acquired by both parties 50-50 in certain countries. In other countries, the discretion has been left to the judiciary, but the judiciary, for instance, in England, has now, as a rule, as a norm, they give 50% of the property to women. But in India, a woman has no right to this marital property at all. She has a right to what is called maintenance, that is financial support for the wife and the child, but she has no right to marital property. If there is a divorce, she has to walk out of the house if a property is not in her name. And even if it is in her name, I'm recently doing a case in the Delhi High Court, even if it is in her name, they say, but she was not earning. She is a housewife. How can you say that even if it is a joint account, that it is half hers or somewhat hers too? A man will do anything. If people have bought articles, household articles with the money that they have got, it will belong to the husband, even though it might be in joint names. So even that doesn't really apply, except for immovable property, where if it is bought in her name, then she can take protection under certain other laws. So this is the situation here. And the government, however, is determined. I mean, they brought one bill, then they brought another bill, because what has become urgent for the government is that several people in certain key areas want a divorce law which is easier, in which it is easier for people who don't want to stay on in a marriage to get out. And I agree, at some level it's a human rights issue. Also, after all, a person should be able to get in and get out of a marriage as they want. But it cannot happen if it is going to create a situation which is highly unequal for women, and where we saw in a survey that women's standard of living, for instance, fell by 70 to 80%, whereas the man's standard of living actually improved after a divorce or separation. So having a Bill of Rights with some of these clauses will help. The other area in which the Law Commission plus the National Commission for Women and ADWA have come out with laws and want a comprehensive law is in the area of honor crimes and killing. However, that's another area in which the Law Commission had suggested that there should be a law, and if there is, as you know in India, and I'm sure you must have heard of the fact that certain community organizations like the Khap Panchayats in a particular area often support the women's family to stop a marriage because they think that it is against the honor of the family, particularly when it is an inter-caste marriage or when it is an inter-community marriage. And for a long time, these Khaps, for instance, in the adjoining state of Haryana, have been acting with impunity. They have been stopping these marriages. They have been adopting various coercive tactics to stop these marriages, and they have been doing so without any action being taken from the government, because elections are around the corner and they do not want to, and some of the governments, some of the people, political leaders who support them are leaders in these areas and do support these organizations, get a vast amount of support from these community organizations called Khap Panchayats and other forms of Panchayat. So the law that we have suggested is a law which will punish crimes related to honor, that is, and which reiterates the right of a young couple to get married, or a marriage and enter into a marriage of their choice. So, if any action is taken against this, we have suggested in the law that the coercive action and harassment should be punished. However, in India, this is not being done as yet. And only when it precipitates into a killing, for instance, of the boy or his family members, is any action taken. And the Justice Verma Committee pointed out that it was a heinous crime. It also referred to the law made by the Law Commission, but unfortunately, it did not refer to the law which was made by the National Commission for Women, because I suppose of lack of time, they didn't have the occasion to look at it. But it raised the issue of the liberty of a person to marry who they want, which is a very important issue which connects directly with the youth and particularly women of the country. The third issue which was raised by the Justice Verma Committee, I have 5 minutes. The third issue which the Justice Verma Committee raised was related to the gang rape case, which I started the talk with. And it raised the issue of how the government had been negligent in implementing the existing rape laws. It raised the issue of how non-implementation of a law was meant that had would mean that the law itself is negated, and how the government was under a duty to implement it. It brought in one place all kinds of recommendations that had been made hitherto on implementation of laws. There had been cases of the Supreme Court which it referred to and said that the police should be structured in a particular way so that they have security of tenure and that they are free to implement laws without political interference and without bribery. The second thing it suggested was that they should be, the second aspect of implementation it suggested was a grievance mechanism in which to which citizens can go to. The third area was the actual change of substantive changes in the laws of sexual assault, which had been brought in to the country with the Indian Penal Code of 1860. We all have the same penal code. which had been brought in with the Indian Penal Code of 1860, until date hadn't changed. Now, what was amazing about the Verma Committee report was that it took into account all the changes that had been suggested. Women's organizations like ADVA and others had been fighting a losing battle with the government. And for several years, I think from 1993, you all will be surprised to know, they had been suggesting change in the laws related to sexual assault in the Indian Penal Code, primarily 3 sections. One was the rape section, one was the section relating to molestation, and the other was a section which related to what was popularly known as eve teasing, but was actually harassment. And in all these sections, various suggestions had been made. The government had changed the law as far as children were concerned, after again a lot of pressure and campaigning, in 2011. But as far as women were concerned, they brought in a bill in 2010, then sat over it till 2012. And the bill again was very inadequate. It was not comprehensive enough. It didn't take into account all the suggestions that had been made. And it was left to the Justice Verma Committee, which really made comprehensive suggestions. They defined consent, for instance. What is consent? As we were saying, that no woman is believed when she says no, it's thought as yes, yes. And what women's groups had been suggesting was that consent should mean the unequivocal agreement to have sex. And unless the Verma Committee actually took the suggestion of the women's organizations and wrote out a defined consent, and stated in that clause that unless the woman says yes, it should mean no. It included marital rape in the definition of rape, which was not included anywhere, and still is not included in the law, because the government, in spite of the report, did not bring it in. It suggested the introduction of an offence of stalking, which has now been brought into the law, and which had not been there in the Indian Penal Code. And the women's organizations and National Commission for Women in its 1990, I think it was suggestions, in 2005 had made the suggestion that please include stalking as a crime in the Penal Code, but it hadn't been. So it did that.